My name is Tommy Coleman. Today, the county attorney sent a clear message by leading the commission sanctioned prayer today. I too have a clear message to deliver. My name is Tommy Coleman, and today I am addressing the county commissioners and all Hamilton County residents. I come to you as a concern.
Could we get your address, Mr. Coleman?
No, thank you. Not at this time. In private, I would be happy to give it to you.
You'll have to give it public, brother.
Okay. It is 1703 Seagull Lane, Hickson, Tennessee. Thank you. You're welcome. I come to you as a concerned citizen, fully supporting the separation of church and state as a legal issue outlined in the Establishment Clause, the Constitution of the United States of America, and as a matter of policy for the County Commission. As I entered your commission chamber today, I left something at the door. What I left behind upon entering this room is the very thing that should never be brought by any government official into any government proceeding. I have entered to address you today in a manner that would honor this nation's founders, and as such, my religious views, beliefs, and opinions remain at that door. That leaves one question to be answered. What did I enter with? I appear before you all today with an overwhelming abundance of respect and reverence for people of all faiths, religions, and spiritual beliefs. If anyone in this room claims to respect the diversity of our county and our country, or purports to respect the Constitution of the United States of America, then as a matter of utmost truth, you must acknowledge that this is not a Christian commission or a Christian government. And as such, there is no need for the commission to open with a Christian prayer, or any prayer for that matter. This is not a Muslim commission. This is not a Jewish, nor Mormon, Baha'i, Wiccan, Buddhist, or any other faith tradition or religious belief, although many citizens of Hamilton County may identify as one of these or more. As a matter of principle, your use of prayer in this chamber and its use in official government business excludes, marginalizes, and belittles other faiths and the people who practice them by its inclusion into your official procedure. As a matter of law, you are in blatant violation of the First Amendment of the United States Constitution. I will gladly support and defend your right to pray and worship whomever you so choose in your private life as a citizen of Hamilton County. But a commission-led prayer while acting as a county commissioner is unacceptable. This commission's sanction of prayer must and will end. I propose that a moment of silence be held in its place to best respect the religious diversity of this county's citizens and to bring this governing body back into good legal standing in accordance with the U.S. Constitution. I proudly applaud the Freedom from Religion Foundation in taking on this matter and have great trust in their support of the U.S. Constitution regarding separation of church and state. Your continued refusal to cease official prayer before commission hearings is unacceptable, unconstitutional, and un-American. If you have any respect at all for diversity of faith in U.S. law, you will replace the prayer with a moment of silence more befitting of your role as good stewards of Hamilton County. My name is Tommy Coleman, and I support separation of church and state. Thank you.
Please state your name and address for the record, please.
My name is Brandon Jones. I live at 418 Macaulay Avenue, apartment 12, Chattanooga, Tennessee, 37402. I also want to address this commission today about its policy on prayers before its meetings. I can only assume that when you read the parts of the Constitution dealing with religion and government, you interpret them to mean only freedom of religion, disregarding freedom from religion. When you take the path that says these things mean solely freedom of religion, you run the risk of treating your beliefs as if they were more legitimate or truer than the beliefs of others, which in and of itself isn't so wrong, and it's in fact probably only natural. We all do that. As G.K. Chesterton, the great Christian apologist, once said, the point of having an open mind, like an open mouth, is to close it on something nourishing. The danger comes, however, when you fail to set these beliefs aside while acting on behalf of what is, by law, a secular government. In effect, supporting your religious beliefs while also representing what is supposed to be an impartial institution that has no stance on any religious belief of any kind. This is, and has been pointed out many times, quite disparaging toward other people's stances on religion and its support of one particular religion over all others. And it's against the Constitution. It really doesn't even matter how vague you were to make your opening prayer, because there are still those who share none of the religious perspectives present within it, and they're protected too. After all, what is the Constitution for, if not to protect the rights of minorities along with everybody else? Right now, you can be sure that there are Christians in other countries suffering the same injustice that is being rendered here in this courthouse at the beginning of each and every commission meeting. I'm certain these unfortunates wish they could be afforded the same protection under their laws as we are afforded under ours. This being said, a law means nothing when it's not abided by, and it means even less when government figureheads ignore it altogether. I cannot sit idly by and watch when this happens. I also don't think it's too much to ask that members of my government be held accountable to the laws created by my government. Myself and others demand satisfaction on this matter, and we will not rest until it has been achieved. We have an impressive track record, actually, of obtaining it as well. In 2002, the ACLU successfully sued this county for posting the 10 Commandments in this very courthouse, as well as 2 other buildings. Not only did Hamilton County fail to get what they wanted when they lost this case, they also racked up $70,000 worth of legal bills. And not only did this county waste $70,000 worth of taxpayer money on what was always a losing battle, they also got something they didn't want: bad press. That case made Chattanooga look like a backwards, small-minded collection of bigots in the eyes of the entire nation. And all because of the same attitude that this commission continues to hold. How much more money is this commission willing to waste on a futile effort? How much worse is this commission willing to let our community seem to be? In 2010, Saudi Daisy High School received a similar letter to the one received by this commission from the same group, the Freedom from Religion Foundation. This time, litigation was avoided because the schools discontinued the act shortly after being told they were violating the Constitution, but not before the same sort of initial denial we see in this commission toward the unlawfulness and lack of ethics about the prayers were overcome. How many more times are we going to keep making the same mistakes in this county before we learn that no religious belief, no matter how much support it might have, is above the secular laws of this county and country? It's also worth pointing out that when other counties have faced the prospect of litigation on this matter, many were naive enough to think that the unfavorable ruling they received could be would be overturned by the Supreme Court. To date, the Supreme Court, definitive on this issue, has denied every single appeal attempt by every single county, the most recent attempt being in January of 2012. Will this commission be responsible for the next failed attempt? As lawful citizens of the United States of America, myself and all those who support a firm separation between church and state demand satisfaction on this constitutional issue. If we do not achieve satisfaction on this matter soon, as concerned citizens, we will have no choice but to involve all interested parties in our continuing quest for equality. This could mean another visit from the American Civil Liberties Union, another communication from the Freedom from Religion Foundation. It could even mean the introduction of organizations not heard from in this county before, such as Americans United for the Separation of Church and State and the Secular Coalition for America. Luckily, there's still time. You still have a choice about whether to continue your flagrant disregard for the Constitution or accept our reasonable compromise of a moment of silence at the beginning of each meeting. We have unwavering legal precedents set by the Supreme Court itself on our side. We have the commonly accepted interpretation of the Constitution on our side. We have the most prominent names in religious civil liberties on our side.
John, let me interrupt you. You've got about 1 minute.
Yes, sir. I'm almost done. We have the most prominent names in religious civil liberties on our side. If litigation were to take place on this issue, we would surely win. Any doubt of this is the very definition of the word denied. We implore you take our fair compromise. The choice is yours today. You may not have that choice tomorrow. My name is Brendan Jones, and I too support the separation of church and state.
Ma'am, if you would state your name and address for the record, please.
For the record, my name is Michelle Hubbs. My address is 8 Shallowford Road, Chattanooga, Tennessee, 37404. First, I'd ask your forgiveness in my casual attire. I did not plan to address the commission this morning. I read in the paper that the gentleman supporting the Freedom from Religion would be here All of you have received my emails. You can now put a face with the name. I am an employee of the county. I work in Chancery Court. I'm going to read the First Amendment. I'm also going to be entering as a first-year law student. And I wanted to put another perspective. The First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and petition the government for a redress of grievances. Justice Harry A. Blackmun stated, when the government puts an imprimatur on a particular religion, it conveys a message of exclusion to all those who do not adhere to the favored beliefs. Gentlemen, the separation of church and state is not a constitutional issue. It was a letter written by Thomas Jefferson to the Danbury Baptist shortly after his election and was meant in a personal context. The day after the letter was written, the man got up and went to Congress and attended a Methodist church congregation, he himself being a deist. His point in this was to prove that the government will not endorse any religion or any denomination, but will endorse the freedom of every individual and every organization and every government to choose who they worship and how they worship. If you were to have to have looked at the diversity of the colonies back when Jefferson wrote the letter, they were as diverse as they are today, just a different grouping. You had atheists, antagonists, Roman Catholics, Jewish. You even had some of different sections that would now be considered almost Muslim. And the point is that none of the founding fathers were any of that, but yet the state of Virginia, Virginia had the Church of England. North Carolina was considered atheist. All of these states had put in a formal document their chosen denomination and faith and were allowed to operate their governments based as such. If you ask me to pray, I will pray in the name of Christ. If you asked one of my good friends to pray, he's going to pray in the name of the Jewish God. You, as a legislative body, according to the letter of separation of church and state, have the right to choose when you will pray, how you will pray, and who you will pray to. If you were to ask these gentlemen to pray, they have the right to choose for a moment of silence. If you were to ask another individual to pray, you should give them the right to pray as a Muslim. But if you ask someone on your own commission to pray and they are a Christian, they have the right to pray in the name of Christ without fear from interference of the government. Same with a municipal body. If you, as the Hamilton County Commission, want to pray every day before you start, that's your business. You have the right to do that. The definition of church and state is quite different than the role that the infamous phrase has been given in our current state and referenced by the foundation. Again, the First Amendment does not guarantee anyone a right from religion. You have the right to freedom of religion, but not from it. So let's be clear. There was no separation between church and state as we currently understand it today in the beginnings of our nation. The phrase from Jefferson's infamous letter concurred the author's heartfelt conviction. The people have the right to choose, hold, and engage in any form of public worship on any property, whether it be public or private, as they see fit, without interference from any person, private or public, as it is their government. Chief Justice Warren Earl Burger wrote in Lynch versus Donnelly, 1985, there is an unbroken history of official acknowledgement by all three branches of the government of the role in religion in American life. The Constitution does not require a complete separation of church and state. It affirmatively mandates accommodation, not merely tolerance of all religions, and forbids hostility towards any. Anything less would require the callous indifference we have said was never intended by the Establishment Clause. Indeed, we have observed such hostility would bring us into a war with our national tradition as embodied in the First Amendment's guarantee of the free exercise of religion. And then I'm going to do my what ifs. What if Justice Hugo Black erred in Epperson v. Board of Education, 1947, when he applied a personal correspondence from a recently elected politician into a judicial forum? That would mean the clause against the establishment of religion by law was intended to erect a wall of protection, not one of restriction. What if the Founding Fathers really meant Congress, i.e. any governing or legislative body shall make no law? That means the Supreme Court should not have heard anything regarding any religion, denouncing one religion, silencing another. Then that would mean the court erred in passing any ruling that restricted any religion, and conversely, that any person, organization, or legislative body may choose to pray to whomever, whenever they like, including governing and legislative bodies. That would mean the current application of the law would need to be modified and corrected to remedy the error. Again, the Supreme Court is setting the precedence in the fact that the current court before us is willing to revisit issues that the court had previously ruled upon and admit that there has been error made in the application of laws. You gentlemen, as a legislative and governing body, you have a unique opportunity to interpret and apply the law that is specific to you, judiciaries, and other men in legislation. You have the opportunity to remedy mistakes and misunderstandings when presented. And those who have been placed in these positions have a duty. You have a duty to at least be open to the possibility that an error has been made, and that perhaps in our day...
We're getting a little close on
Okay.
time. We've got one more speaker. I know it's Mr.
Okay.
Chris.
Political correctness has been allowed to morph into a rare form of hybrid discrimination. If you silence one religion, you silence them all. If you silence Christianity, you silence atheism as well. That's it. Thank you for your time.
Commissioner Beck, you want to be recognized?
After this one, I would like to recognize her again, please.
Okay. State your name for the record, please, and your address.
My name is June Griffin. I live at 265 Crestview Lane in Dayton, Tennessee, but I own property in Coulterville, so therefore I am a Hamilton County taxpayer.
Please stop her. Stop her. I need to ask some questions.
What I'm going to address, I'm also a chaplain of the American Legion Auxiliary in Dunlap, Unit 190. In 2005, the American Legion passed a resolution that has gone to Congress every 2 years to put a stop to the legal fees that are being collected by these nonprofit lawyers. That includes Freedom from Religion, the ACLU, etc. That resolution, which was written by Reese Lloyd, who's an attorney and a friend of mine in California, of all places, it is going to put a stop and has been reintroduced into Congress, even though it is doubtful any real American Civil Liberties Union knows about this. The congressman will not recognize it, but we are in the process of getting your $70,000 back with interest, and the ACLU is going to have to pay back all of that money that they have stolen. In the case in Knoxville, Tennessee, when the ACLU did not want pornography to be seen by their students, the ACLU filed, of course. And so I filed an intervenor suit as a taxpayer. And because our money is being taken from us by income tax and going to Washington and rained back on the county and from the Department of Education, the judge allowed my intervention, and the ACLU did not get paid. In the Cheatham County case, it was a different story because we had a different judge. Different judges disagree on this or that because they went to different law schools. And evidently the law school up in Knoxville had a better idea of what was right and wrong than the lawyer in Cheatham County. This was federal judges. I was the one that gave you the copy of the Bill of Rights. Patrick Henry, a Christian, gave you the Bill of Rights. He knew that unless we had a Bill of Rights, which none of these ACLU lawyers and the Freedom from Religion do not recognize the 9th and 10th Amendment, which I hope I will have time to read. And it says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The powers not delegated, Amendment 10, to the United States by the Constitution nor prohibited it by the states are reserved to the states respectively or to the people. I say put this to a vote. Put it on the ballot. If the people in Hamilton County want to be multicultural and they want to have everybody in their Tom, Dick, and Harry or whoever are non-Tom, Dick, and Harry, if you want them to not have any prayer, then let the people vote. But get these lawyers out of the picture. Left wing, right wing. They're all on the check. They're all getting the nonprofit money. They get donations, and then they come out as the savior, either for the liberals or for the conservatives. Secondly, remember that 9th and 10th Amendment, which the ACLU, the head of the ACLU told me personally in the legislative halls, she does not recognize the 9th and 10th Amendment. That's what gives Hamilton County jurisdiction to do what you want to do. And you can't steal one amendment, the first one, and ignore the 9th and 10th. This is where these people, these lawyers, do not recognize the 9th and 10th Amendment. You all have the authority in Hamilton County, you have the authority in the state of Tennessee, and Tennessee has just recognized that by unanimous vote, authorizing the posting of our commandments. I don't know if I can get y'all's commandments back. Remember, we bought them, took them up to Ray County. They're safe there. Let's have the confrontation. You come on out and I'll sing a few songs. We have gospel music everywhere in Jesus' name. There is no other name given in heaven whereby you might be saved. We need salvation. Attorney Taylor is very qualified to defend the Bill of Rights. We don't need any outside lawyers involved in this. I've already talked to your atheist lawyer up in Wisconsin, and when I said something about eternity, he had to go. I urge you to resist the devil. It says in 1 Peter, he's an adversary running around the United States seeking whose tax dollars he may live on. It's going to stop, and we're going to get that money back. Judge Roy Moore's going to get his money back. Y'all are going to get your money back. Cheatham County's going to get their money back. The Bible says, restore what was stolen. I admonish you, I am a taxpayer here. But if you put this to a vote today, just like those poor people of Hamilton County who were stepped on by these rotten communist ACLU lawyers, when they had their 10 Commandments hauled out, they stepped on the rights of the people of this county, and it is not going to continue. You know, I was listening to the
Ms.
office
Griffin,
talk.
thank you, but that's about the time. That's pretty much exhausted. We have a commissioner that has a question. Ms. Hood, could you come back just a second?
Now, did you still have your paperwork with you?
Yes, I gave it to the gentleman over here.
Yeah. You have, no, that's okay, that's okay. But you said you were, what were your qualifications now for the very brilliant presentation that you made, and I commend you, and please forgive my sunglasses and looking at you, I can see you. But I left my real glasses, so please forgive me. But what did you, give me your background again,
My
your
background,
study background,
I'm an employee of the Clerk and Master's
and your
Office.
training, please.
My training, I have worked as a paralegal for 10 years in various different areas of the law, and I am starting my first year of law school in August in Atlanta. I have been accepted into Stetson in Florida and a couple other Ivy Leagues in Texas, but my faith called me here. So I am going to John Marshall in Atlanta. This was actually written in an essay over a year and a half ago for one of my submissions to law school.
And the third paragraph, would you read that for me again?
From the top page, on the first page?
First page, and third.
Seeking protection?
Yes.
Seeking protection from religious persecution, the Danbury Baptists had hoped they had found a religious ally in Jefferson based upon his writings contained within the foundational documents of their young nation, the basis for the revolution. Wary from lessons learned in the past and keenly aware of the current political environment surrounding his election, Jefferson would no more assert one form of religion over the other, asserting it was the people's right to worship or not worship, however and wherever they deemed fit and proper. Although not a Christian himself, the very next day Jefferson would attend a Christian church service held within the halls of Congress as a testimony to his belief in this right. The people have the ability to worship or not worship God as they saw fit, each individual, every community, every organization, public or private. Each colony, each branch of local government could assert whatever form of governing body it saw fit, be it Puritan, Quaker, Protestant, Jewish, or no religious sect at all. This is what was and is meant by the separation of church and state, intended only for its specific political context, by way of answer, sowing useful truths and principles among the people, which might germinate and become rooted among their political tenets. Jefferson never determined for his letter to be applied in a legal forum, nor did he or the other founding fathers intend for the courts to be the final authority in devising and creating laws. The fourth president, James Madison, stated, "As the courts are generally the last in making the decision, the results to them, by refusing or not refusing to execute a law, to stamp it with its final character. This makes the judiciary department paramount in fact to the legislature, which was never intended and can never be proper. Within the court's legal forum, the phrase has been applied in opposition of the originating authors and founding fathers' intentions."
Well, thank you so very much, and that was very well put. And I'm looking forward to the great things that's going to be happening in your career as time goes on. Thank you very much.
Thank you, sir.
Do we have any other individuals or delegations that want to address on any other subject other than zoning? Seeing none, we'll be in recess until June 14th.